Okay, welcome everyone. We're just going to get started here today. We've got a lot to cover, and I'm sure we'll have attendees joining us over the course of the next couple of minutes, but I'd like to welcome everyone for joining today. I'm Cassia Furman. I'm the managing partner of Vicente Sederberg's California practice group based in LA. And with me are some colleagues from our Los Angeles and San Francisco offices. We have Christina Sava and Andrea Golan, who are both regulatory and compliance attorneys with the firm, as well as Genevieve Meehan, who is a licensing and regulatory specialist and our California metric and compliance guru. And we're here today to talk about the exciting topic of California packaging and labeling. Those of you who have been clients and colleagues of the firm since the start of California's legal market in 2018 have been with us through several iterations already of the packaging and labeling regulations for California, and know that we're in an atmosphere where compliance can really make or break a business's success in the cannabis industry. And maintaining compliance is just an ongoing, challenge that changes. Sometimes it feels week to week, and at the very least month to month and year over year in California. It's our country's largest cannabis market, and we constantly have new brands and companies coming in and out of the space, complicating the packaging and labeling landscape have been both the multiple changes to the regulations that were enacted, first in 2018, substantive revisions in 2019, and now in 2020, still new regulations. We've seen changes to things like child-resistant packaging, the universal symbol being required on vape cartridges, exit bag requirements, Prop 65 requirements changing. Some of these regulations are referenced directly in the cannabis regulations, and some of them are in other statutory and common law authority in California. So it is a complex landscape, and one that requires an operator to stay on top of trends, stay on top of developments, and also interact with distributors and retailers who are charged in California with quality assurance testing. So one of the sort of dynamics that we've seen really play out in the market here, especially in 2018 and 2019, but still now in 2020, is a situation where the supplier, the brand responsible for packaging and labeling initially, feels that their packaging is compliant. Then we get to a distributor or retailer doing a supplemental check who has a different interpretation of the regulations, which are so new in California. So we've navigated a lot of those issues and have some guidance to share with you today. We're going to talk about turning a product idea into a product launch, which is going to be the first topic covered by Genevieve, and provide an overview of packaging requirements as well as labeling, including Prop 65 and the new changes to Prop 65. We're also going to touch on the upcoming OCAL and Appellations of Origin programs, which present some exciting opportunities for cannabis companies to distinguish and further develop their brands in an environmentally sensitive way. And then talk a little bit about troubling in the supply chain. Those are the learning objectives for today. We thank you for joining us. Please don't hesitate to write questions down in the chat function on the side of your screen. We will try to reserve some time at the end for questions. And if we aren't able to address your questions, please feel free to follow up with us after the session. And without further ado, I'm going to turn things over to Genevieve Meehan. Thanks, Jen.
Thanks so much, Cassie. I appreciate it. Glad everyone could join us today. So I'm going to first talk through turning a product idea into a product launch and what that looks like for your packaging. Planning ahead and thoroughly understanding labeling requirements for all of your product lines can ensure a smooth transition into market. Minimizing these concerns in advance allows for you to prioritize the sometimes tight production timelines that lead up to your distribution pickup date. Establishing and enforcing packaging and labeling compliance protocols will also impact your bottom line and with improved efficiency and consumer confidence, and help you avoid unnecessary supply chain issues or compliance crises. Early in the process of product development, it's important for you to identify your product type. As we'll discuss throughout this conversation, your product type dictates your packaging and labeling compliance requirements. For instance, edible products must be kept in opaque packaging. It's also important for your compliance and quality assurance checks to incorporate your design team or marketing individuals who are associated with product development. If you include your creative team, as well as those involved with recipe or formula development, if applicable, into your compliance overviews, you can have an additional assurance regarding compliance. Individuals working on the look and feel of your packaging should have an understanding of cannabis regulations. The regulations dictate the placement of required content on your label, and in many cases cannot be modified. It's important for your creative team to know what goes on the primary versus informational panel, which Andrea will discuss further, what kinds of language can or cannot be used in your marketing techniques and on your packaging, and what information cannot be removed, have the color changed, etc. When picking new packaging for a product, it's also important to include any team members that are focused on production in your conversations. Ingredient lists, including allergens, should always be confirmed by someone who is directly involved in the recipe development and knows what goes into the product. It's also important to get input on the packaging processes in production. Consider what might be easiest for your production line. Child-resistant packaging can be difficult to assemble, open, or close, and items like this should be considered in advance and when thinking about the labor involved with packaging your goods. Your team may have some valuable input on what will or will not work well in the assembly line, so letting them see samples and have input early can really impact how smoothly things go. Compliance checks should be done early and repeated often. Fixing mistakes after printing can be very expensive, time-consuming for your team, and ultimately the time it takes to get your product into the hands of the consumer can be delayed. Utilize internal checklists, create documentation for review of your mock-ups or copies, double-check child-resistant certification on your samples, and even ask us at VS if you do have additional questions or concerns that come up. With that, I will turn it over to Christina, who will give us some more information on what you should look for in your packaging.
Thanks, Jen, and hi to all of our attendees. We're going to go over a few general packaging requirements that apply to all cannabis product types. So first of all, the packaging has to protect the product from contamination and cannot expose the product to any toxic or harmful substance. And of course, this can be an issue at your end of the line testing. So you do want to make sure that your packaging is not going to expose your product to any foreign substances. And all packages must be tamper evident. This means the contents can't be opened without obvious destruction of the seal. So the packaging regulations actually don't specify which layer of packaging has to be tamper evident, as long as the consumer can see if the product has been opened prior to consumption. So having a seal over the top of a bottle underneath the cap would be okay, for instance. And if the product has multiple uses, the package has to be resealable. And all packaging must be child resistant, and that can be defined in a couple of ways, which we will explore now. So for something to be certified child resistant, it indicates that it's compliant with the Poison Prevention Act, which is found in the Code of Federal Regulations. And the Poison Prevention Act actually outlines a scientific method of testing child resistance. It involves using groups of 50 children of varying ages, and the regulations outline a very specific procedure for administering the test, and then the packaging has to be unopenable a certain percentage of times. All of this is to say that it's probably impractical for you as a licensee to administer your own Poison Prevention Act child-resistant testing. And so your packaging manufacturer would actually be able to provide you with a certification and associated report proving that the packaging has gone through the required testing and is in compliance with the Poison Prevention Act. And we have here on our slide an example of such a certification cover letter. And you're going to want to request the certification before you order packaging. And then you want to keep the certification in your records, showing that you've done your due diligence to ensure that the packaging complies with the Poison Prevention Act. Also consider that if you are modifying the packaging in any way, it might alter the validity of the child-resistant certification. So either don't modify packaging or work with a supplier on this matter. So certain products don't need to actually be certified child-resistant. Cannabis flower and cannabis products intending to be inhaled or single-serving cannabis products can meet the child resistance requirement if they're in plastic packaging and the packaging is 4 millimeters thick, heat sealed with no easy open tab, dimple, corner, or flap. And if we go back to our previous slide, we can see that these bags here actually do have an easy open dimple, so they would not meet the requirements for child resistant. And if you have a single serving bottle, you can meet the requirement by having a pry off metal crown, not the twist off metal crown. So the type of product dictates how long the packaging has to be child resistant. Lifetime child resistant means that the product can be opened and closed, but it remains child resistant for the life of the product. And the lifetime child resistant requirement applies to edibles, orally consumed concentrates, such as tinctures, capsules, and tablets, and suppositories. And if you have a package with more than a single serving, the outer packaging doesn't have to be child resistant as long as each serving inside is packaged in a child resistant packaging. And then other items, other products can be child resistant just until their first opening. This applies to flower and other cannabis products intending to be inhaled, such as dabs and shatter and wax and also cartridges. And these types of packages have to be labeled with the phrase, "This package is not child resistant," after opening. So there's restrictions on certain language and images that can appear on a package. Like Jen said, these are things you want to get clear on with your design team before designing and printing and ordering packaging. So first, you can't use the name of a California county, including any similar name, unless 100% of the cannabis contained in the product was grown in that county, and this is known as our County of Origin program. You can't use content that is designed to be attractive to individuals under 21. This can include cartoons, any likeness to characters or phrases that are popularly used to advertise to children. You can't imitate all that already existing candy packaging or labels. And you can't use the term candy or candies or any variants of the spelling of the word candy. And you cannot imitate packaging used for products typically marketed to children. And you can't include any information that's false or misleading in general. For instance, of course, you wouldn't want to say your cannabis is outdoor grown if it was actually grown indoors. And the regulations prohibit you from making a health-related statement that is untrue or misleading. So in the non-cannabis food and supplement world, health claims do have to comply with certain FDA requirements. And so we haven't seen the FDA enforce its dominion over health claims when it comes to state-regulated cannabis products. But California law generally mirrors the FDA health claim standards. And so it is wise to be cautious when making health claims and health-related statements. And you probably do want to have an attorney review these for you. And I'm going to turn it over to Andrea to talk about labeling requirements.
Good morning. I'm going to talk about primary and informational panel label requirements. So the primary panel is the part of the product label that is most likely to be displayed to the consumer at retail sale. And all products, manufactured and flower products, require the following information on the product display panel. The product identity statement, which is the name that describes the product, vape cartridge, pre-roll, tincture. So it's not the brand name, it's what exactly is inside the package. That's your product identity. The universal symbol, which must be black and at least 1/2 inch by 1/2 inch. Your net weight or volume of the contents of the package in both US and metric units. For edible products, the words cannabis infused need to be just above the product identity in bold type and in a text size larger than the text size used for the product identity. The informational panel is any part of the product label that's not the primary panel. The following statements are required on the informational panel for flower and uninfused pre-rolls. The name of the licensed cultivator or the licensee packaging the product, and that's either the legal business name or the registered DBA for the licensee. The licensee contact name or web address, the UID, the tracking number issued through Metric, the date of packaging for retail sale, the government warning, which must be in bold print and all caps, and the cannabinoid content, again, for flower and infused pre-rolls, it's expressed as a percentage. The informational panel requirements for manufactured products have similar requirements to flower and uninfused pre-rolls. However, you'll note the items with asterisks. The items with a red asterisk can be either on an informational panel or on a supplemental label, such as a hang tag, insert, fold out label, but that supplemental option is not available for flower and uninfused pre-rolls, only for manufactured products. So again, you need the UID, batch or lot number, cannabinoid content in milligrams for manufactured products, the licensed manufacturer's name and contact number or web address. You'll see the date of manufacture and the date of packaging can be listed as one date, as you see there in the example. The government warning, the product ingredients, which I'll talk about a little bit later, and instructions for use. And if applicable, a best by date, or if perishable, a keep refrigerated or refrigerate after opening warning on the product. And again, just everything except for the UID, the batch or lot number, and the cannabinoid content can be placed on a supplemental label. Edible products. So some special considerations for edible products. You need to list your ingredients in descending order by weight or by volume. If any of your ingredients contain a sub-ingredient, you have two options. After the common name of the ingredient, you can put the sub-ingredient in parentheses in descending order by weight. For example, semi-sweet chocolate chips. You can put semi-sweet chocolate chips, and then right after in parentheses, you would put sugar, unsweetened chocolate, etc., and then go on with your other ingredients. The other option is just to list all the sub-ingredients and individual ingredients together in descending order by weight or by volume. Allergens, look at your ingredient list, see if your product contains any major food allergens. You see the list there. I don't think fish and shellfish are going to be too applicable here. Tree nuts is a big one. You might be surprised what's on the list of tree nuts. If you go to fda.gov and you search allergens, you can see their list of tree nuts. Some examples are almonds, walnuts, pecans, and several others. So be careful. If your product contains tree nuts, you need to warn the consumer. Natural and artificial flavors and artificial colorings also need to be clearly listed in your ingredients. And you need nutrition facts. And that means sodium, sugar, carbs, total fat, per serving in grams or milligrams, and also per package. If you have a product that has multiple layers of packaging, and if the container that holds the cannabis or the cannabis product is separable from the outermost packaging, the immediate container that holds the product must contain certain labeling. Inhaled products like vape cartridges, shatter, and wax, the universal symbol needs to be put directly on the product. For vape cartridges and vape devices, they must also be directly labeled with the universal symbol. The vape carts and devices, the label can be, the universal symbol can be 1/4 inch by 1/4 inch and can be in black or white. Non-inhaled cannabis products and edible products must also include the same elements that I discussed earlier that go on the primary display panel. That's the product identity, the universal symbol, and the net weight or volume. And for edible products, the words cannabis infused must also be placed on the immediate container that holds the product. And we've talked about some of these, but I want to highlight some of the key differences between flower and manufactured product labeling. Again, edibles require the words cannabis infused above the product identity. Edibles must be in opaque packaging. You can't have images of the product or pictures of the product on the outside of the packaging. The government warning on flower varies slightly from the government warning for manufactured products. For manufactured products, there's verbiage in there about effects being delayed up to 2 hours, and there's a couple other minor differences in words, so just take a look at your warning symbol. You can't use them interchangeably for flower and for manufactured products. Also, as I mentioned, flower and uninfused pre-rolls, the informational panel statements have to be on the package. They can't be put on a supplemental label. And also for flower and uninfused pre-rolls, the licensee name can be either the licensed cultivator or the licensee packaging the product. So just to transition a little bit to Prop 65. So Prop 65 requires businesses to inform Californians about exposure to certain chemicals known to cause cancer, birth defects, or other reproductive harm. Just a disclosure here, I'm only discussing the label requirements. Prop 65, known as the Safe Drinking Water and Toxic Enforcement Act of 1986. It's a complicated statute, and there are defenses to warning requirements that I'm not going to discuss here, such as whether the chemical is naturally occurring or below the level of exposure requiring a warning. I'm not going to address those here. Again, just primarily label requirements. So Prop 65 applies to businesses with 10 or more employees at the time of exposure. So not the time that you manufacture the product, but at the time that the plaintiff alleges an exposure to the chemical that's contained on the Prop 65 list. And employees is broadly defined. It includes both full and part-time employees, including seasonal employees, officers and members of boards of directors that are rendering services for pay, working members of a partnership or LLC that receive wages, and all persons who don't meet California's definition of independent contractor. Additionally, any related entities along with your entity, together they could be construed as a single entity for counting the number of employees. So be careful with that 9 or less employee exemption. Penalties for Prop 65 warnings can be up to $2,500 per violation. So a violation is not defined. What's considered a violation is not defined in the statute, but it's typically calculated by the number of units you're selling in California within the past year of the time of the exposure. So those penalties could be pretty hefty. And if you're selling products over the internet, and I know you're not selling cannabis products over the internet, but if customers are ordering for delivery over the internet, these Prop 65 warnings need to be both on the internet and on your product. Most cannabis products contain at least one chemical on the Prop 65 list. Chemicals that could be in your cannabis products that are on the Prop 65 list include beta-myrcene, which is a terpene, isoprene, heavy metals, lead found in soils, chemicals used in cultivation, and exposure to cannabis smoke. And that includes smoking accessories. So if you're selling smoking accessories, those two needs to be labeled with a Prop 65 warning. And you'll see on the slide, and if you can also search it, you can go to the Prop 65 website and see a list of chemicals and see if there's any ingredients in your products that are on the Prop 65 list. So, new warnings in 2021. So just this past January of 2020, cannabis smoke and Delta-9 THC were added to the Prop 65 list as reproductive toxins. Cannabis smoke as a cancer-causing chemical has been on the Prop 65 list since 2009. But again, now it's a reproductive toxin as well. Businesses have until January 3rd, 2021 to comply. Watch out for this grace period. Products that leave your manufacturing or distribution facility without a warning prior to January 2021, but end up on the shelf after January 3rd, 21, are ripe for exposure for a plaintiff claim. And these Prop 65 violations are typically enforced by private plaintiffs, and often they go out immediately after the grace period ends in search of newly listed chemicals. So make sure you have those Prop 65 warnings on well before January 3rd, 2021. I just provided some examples here. What you see here is a long form warning. Now the Prop 65 warning, there's two options. For the warning statement, there's a long and there's a short form warning. Both are compliant. And what you see here are the elements for the long form warning, which is the symbol, the word warning in all caps and in bold print, and then the words "this product can expose you to," and then you can list one or more of the chemicals that's in your product. You don't have to list all of the chemicals, and then the website URL for the Prop 65 warning. So those are the elements for a long form warning. And you'll see here on this example, there's an example for a product that just contains carcinogens, a product that contains reproductive toxicants, and a product that contains a chemical that exposes the consumer to both carcinogens and reproductive toxicants. And here's an example of a long warning for a product that contains two chemicals, one of which causes both reproductive harm and cancer, that's cannabis smoke, and one which is known to cause reproductive harm only. So again, a long form warning, you list the chemical and you list the harm, you have the triangle symbol, and you direct the consumer to the website for additional information. And then the type of exposure, whether if it's cancer or if it's reproductive harm. And right there in the bottom in the box, we have an example of a warning for a product that contains chemical or chemicals that cause both cancer and reproductive harm. So that's what the warning would look like if your product contained cannabis smoke, or causes an exposure to cannabis smoke, I should say, or any other chemical that causes both cancer and reproductive harm. Placement. Now, this is a question that we get a lot. You know, where do I need to put the label? Now, the standard is the label or the warning should be placed in a manner to ensure consumers receive the warning prior to exposure. So if an exposure can occur upon opening the package, the warning has to be visible on the outer packaging. But a business is not required to provide a warning on both the packaging and the product itself. So for example, you're not going to be exposed to cannabis smoke upon opening the package. However, in best practice, and we always advise our clients to place the warning on the outer layer of the packaging so that the consumer can see it prior to purchase. Internet warnings. So if your product is sold on the internet, you know, for delivery, in the case of cannabis, you know, if your consumers are searching for products online and ordering for delivery or otherwise, the regulations require a separate warning for internet purchases. So this is in addition to the warning on or with the product. So it needs, if the warning is on the product, it also needs to be on the product display page or before the consumer checks out. You can provide a hyperlink with the word warning, or you can display a picture of the Prop 65 warning. Again, the short or long form warnings are both compliant. The key thing is that the consumer sees it prior to completing a purchase. And just a few other packaging and labeling. Oh, actually, let me go into OCal here. Great. So just to transition from Prop 65 to California's organic program, when medicinal and adult use laws came into effect, the Department of Agriculture was mandated to put in place a state-level organic certification program for cannabis by 2021. The California Department of Public Health, which oversees the manufactured cannabis safety branch, is required also to establish an organic certification program for manufactured products by July 1, 2021. So the program will be split into two parts, with CDFA certifying growers and distributors, and CDPH will be certifying manufacturers. So the term organic, it's a federally designated term, and it can only be used with the consent of the federal National Organic Program. But cannabis can't use the term organic because cannabis is still considered a Schedule I drug. So the term organic in California will be replaced with the alternative term OCal. The OCal program largely mirrors the National Organic Program. In May, this past May, CDFA released proposed rules for public comment. That public comment just closed this past week. What I've listed here are the proposed regulations. So I list them here with a caveat that they could certainly change before January 2021. As they stand now, products that are 100% OCal grown can freely and prominently display the term OCal and the OCal seal. The name of the cultivator's certifying agent needs to be on the package as well. The certifying agent, the seal or logo or name of the certifying agent will need to be on the packaging. And again, you can't make any claims that the product is organic or use a variant of the spelling organic. But like I said, you can use the OCal symbol and term freely on all of your packaging. And with that, I will hand it off to Christina to talk about Appellations of Origin.
Thank you, Andrea. Yeah, the Appellations of Origin program is a really exciting development in California, in the California cannabis industry. So most of us are familiar with appellations as they're applied to wine, such as Napa Valley or the word Sonoma. Brie is actually an appellation. That's why we have a picture of Brie cheese there. And so is champagne. And so when a product uses these words, it means it was produced in a certain geographic region, often using a specific production style. And unless the product was produced in the specified region using the specified style, it cannot use the word Brie or champagne or Napa Valley or Sonoma. And soon, cannabis produced in certain regions of California using certain cultivation styles will also be protected by an appellation of origin. So CDFA is creating the first ever Appellations of Origin program for the cannabis industry, and this is really significant because cannabis producing regions around the world are watching to see how the California model unfolds. And so when an appellation of origin is established, licensees will be prohibited from creating advertising, labeling, marketing, or packaging that contains a name similar to an appellation of origin, such that consumers are likely to be misled as to the type of cannabis contained in a product. And so the program's going to roll out by January 1st, 2021. We've already seen draft regulations, and the comment period for those did close. You can still find the draft regulations on the CDFA's WetCal Cannabis website. So you can see kind of what they have been thinking about, what some of the major elements are. One thing, the draft program involved groups of CDFA licensees petitioning the CDFA to establish an appellation. And these petitions would specify the region and the cultivation style and the particular cultivars that would be required if someone wanted to use the appellation of origin that they come up with, the name that they come up with. And the draft regulations also included a sunset clause for names that are similar to an established appellation. So that means that a licensee that owns a trademark that uses the word Humboldt, for instance, if an appellation of origin is established for Humboldt County, that licensee would be required to stop using the name after 3 years is the proposed timeline, or come into compliance with the standards, practices, and cultivars established for the use of the word Humboldt County, the name Humboldt County. And in the comment period, many interested parties suggested that 3 years was actually too long of a sunset period. So we will see how the CDFA either shortens it or maybe they'll keep it at 3 years, but we can expect to see a sunset period for trademark names that might be too close to an appellation of origin. And until the program is established, names of cities and geographic regions can be used, but please remember that we already have some restrictions around the use of county names through the County of Origin program, so you shouldn't use a county name unless 100% of the cannabis is produced in that county. And there's a restriction on marketing and statements that are false or misleading in general. And so if your product has no connection to a certain place, but you're using the name of that place, you might want to rethink your branding on that. And keep a close eye out for the final regulations. It'll be exciting to see what the CDFA comes out with. I'm going to turn it over to Jen.
Thank you to both Christina and Andrea for all of that content. So I'm going to talk a little bit about choosing a supplier for packaging and labels and things to look out for when you're in that process. One of the first things before we kind of dive into suppliers generally is kind of a caution against ordering in bulk in certain circumstances. Ordering your packaging or labels in bulk is an attractive option, especially when you're bringing a new product to market. Increased quantity in your orders can help keep your costs of goods down, but consider any trade-offs that you might be making. If you order in bulk, it often increases the need for changes down the line. So especially with a new product, when it's hard to determine the exact rate at which you're going to sell through your goods, you may have that packaging for a long time. In those instances, you're going to want to consider several different things, including new or innovative designs that may come forward for your product. Think of innovations we've seen in vape cartridges or topicals packaging just in the last couple of years. Also consider any changes in your requirements that may impact what's printed on your packaging. As Andrea mentioned, we're going through a transition with the Prop 65 requirements. So if that is printed on your packaging, that's something you may be stuck with for some time. I think it is very valuable and important to plan and order your packaging early, as it can be time consuming, but also consider that ordering too preemptively may also cause a need for changes. For an initial product launch, it may be valuable to consider an initial run of packaging just to see if you have feedback from any of your partners in either distribution or retail, or even if you receive customer feedback on your branding, design, or other items. You should incorporate all of that feedback into further design. Next, I'm going to talk a bit through supplier relationships. As a best practice, raw materials, ingredients, and anything else that impacts the safety of your finished cannabis should meet your team's quality specifications. Supplier relationships and verified suppliers are important when it comes to the quality of your packaging. With packaging, having a solid supplier relationship becomes increasingly important when you're considering the requirements that Christina outlined for us on packaging. You need to trust that the packaging that you receive is CR certified, truly protects from contamination, and represents your brand well when it's on the market. Establishing a good relationship with a supplier, especially one that has extensive experience in operating in the highly regulated cannabis industry, can put your mind at ease and making quick and sometimes stressful changes to your packaging and labeling on tight timelines a lot easier. This slide kind of indicates some recommendations. As you work through the design discussions on your packaging and labeling, it's common to review the primary and informational panel requirements that Andrea described to us. And you may also want to consider what makes the most sense to print directly on your package versus what makes sense to put on a label that you sticker on in-house. This is a rough guideline, but one thing that we very frequently see printed on a label that's even printed in-house are your 24-digit UID from Metric, your batch or lot numbers, and any required dates, including an expiration date if applicable. It is important to carefully monitor these things for typos, especially on any in-house printed labels. Your 24-digit UID can be daunting to type out, especially on a small label, but it does truly impact the traceability of your product. Printing directly on the package is advantageous because it saves time stickering during production. But again, as we kind of indicated, some things may change on you. Things that we frequently see printed directly on packaging and are generally safe to do so are any of your company's branding, imagery that you use to define your product, the universal symbol, your product identity statements, and the website or contact information that you choose to provide. As I kind of mentioned, it's not uncommon to need to sticker over something in the cannabis industry. I think, especially as we've seen these new regulations, which are now pretty established, but as we've seen things come into effect, it's been a common practice to sticker over what may be on a package or a pre-existing label. There are a large number of online retailers that claim to sell compliant cannabis stickers to be utilized for this purpose. And it does seem like a great quick fix for any typos or compliance changes that your team may need to rectify, but they come with their own compliance concerns. In the example that is on this slide, which can be purchased online very easily, there are several glaring issues, including missing words. My eye is immediately drawn to delaying up to 2 hours, which is an inaccurate phrasing of what the government warning should actually state. So we can also not verify the size of this font or the size of this universal symbol to make sure that it meets compliance. And just from looking at this online, the order minimum on a sticker like this was pretty high. So if you make a misstep and you do order a label that doesn't seem like it can be returned, you may end up with a lot of them. In instances like this, I think it's best to work directly with the supplier so you can really ensure that all of your needs are met. Another thing that frequently goes directly on any kind of batch labeling is your cannabinoid content labeling. It's another area that can be misunderstood, so I'm going to talk us through it relatively briefly. For manufactured products, as Andrea described, the cannabinoid content should be expressed in milligrams. Cannabinoid content may be included on the product label at the manufacturing premises prior to release to distribution, or it may be added to the product at the distribution premises after issuance of the regulatory compliance testing COA for that batch. If labeled on the manufacturing premises prior to testing, the cannabinoid content on the label must be within 10% of what is on the final COA. If labeled on the distribution premises after testing, the cannabis product must be labeled with the exact cannabinoid content specified on the COA. If you choose to apply the cannabinoid content in advance of COA issuance, I strongly recommend sending that product for potency R&D testing before you label so that you can calculate your own variance and make sure you're within that threshold. For flower, the cannabinoid content should be expressed. Oops, I guess I jumped ahead here. For flower, the cannabinoid content should be expressed as a percentage. Flower can be tested in bulk and packaged and labeled later. If you have a product that's infused pre-rolls, the pre-rolls must be labeled with the cannabinoid content in milligrams or the cannabinoid content of the dried flower expressed as a percentage and the added cannabinoid content in milligrams. Next, I'm going to talk through some of the distribution quality assurance checks regarding cannabinoid content labeling. This is something that distributors should always be verifying, especially if that distributor is facilitating the issuance of the COA. If the product is labeled in advance of testing, this calculation on the slide should be utilized to calculate the variance. The lab does not always verify the potency on a pre-labeled product in advance of issuing the pass. So because of this, sometimes your lab results will state that it's a pass when the potency is actually out of that 10% variance range. That would actually be considered a fail for label claims. It is something that can be rectified through relabeling and coordination with regulatory agencies, but it does need to be addressed. So if you have something that's labeled pre-testing, always verify after the COA comes back. Don't just trust that pass that's issued. Next, this kind of leads me into troubleshooting in the supply chain. Each licensee is individually liable for products that are in the supply chain that it's taken possession of. So it's important for packaging and labeling to be verified each step of the way. Each licensee may also have their own unique interpretation or perspective of what does or does not make the packaging and labeling compliant. As the California cannabis community becomes more familiar with the requirements, we're seeing this to be less frequent, but it is important for licensees who are working together to collaborate to ensure compliance. I've outlined some best practices for both distributors and retailers. For distributors, as a best practice, you should collaborate directly with the licensees that you expect to receive large shipments from. You can kind of address any compliance concerns on packaging or labeling early this way, which allows a bit more time for problem solving. In addition, I think that the distributors then have the ability to verify packaging and labeling before receiving a final shipment, which saves the inventory management team time during receiving, especially with quality checks. So if your inventory team is already aware that this child-resistant certification for the specific package has been reviewed and approved, that saves them a step as they're moving through when they're bringing a big order in the door. Distributors should also check case labeling. In addition to what's directly on a product, they need to verify that all required information is present on a case before it ships to retail. This is going to help keep all parties in compliance. As a best practice, retailers should review all incoming product for compliance utilizing a checklist. I advise that managers sign that checklist and include it with the shipping manifest for your internal records so you're aware that that went through a quality assurance review. If issues are spotted, the retailer should immediately contact distribution, and they should reject the order if there are any ongoing concerns. I want to also note that a rejection of an order means the product goes back to distribution. For a retailer to reorder that product into their inventory, it's a new PO and a new shipping manifest. This is time consuming. The rejection of an order based on compliance, depending on the distance between the two licensees, which in the state of California can be large, can mean that there's 2 or 3 weeks before orders are fulfilled. This can delay invoicing and payment and ultimately impact sales for all of the licensees. That is all I have for now. So I think we're going to move into addressing some of the questions. Or Cassie, I'll turn it back to you.
Thanks, Jen. We actually received one question from our guests and attendees, which must mean that we answered everyone's questions preemptively during the session. The question was, if a vape cartridge is placed in a bag that has a certified CR mechanism used for multiple openings, are you able to utilize the tear notches as the tamper evident component for the tamper evident requirement? And we circled around internally. I think we all agreed that yes, that would be compliant so long as the underlying Ziploc is CR certified, which isn't always the case. So if it's a compliant Ziploc, then the tearaway notches should be considered compliant for the tamper evident requirement. So if we don't have other questions, if folks want to send them in right now, we can respond to them. And also, we do want to make this series on compliance and regulatory questions an ongoing series for the benefit of our clients and colleagues and friends. If you have suggestions on topics that you would love to do a deep dive on with us, please do reach out to us and give us those thoughts. We have some topics that we'd like to share for the rest of the year and have identified some things that we think would be fun to cover. Not as much fun as packaging and labeling, but still fun to cover in this type of format. But would love to hear from you as well. And if you're watching this on replay or have any questions that come up later in the afternoon after you've had lunch and had time to think about it, don't hesitate to shoot any of us an email. Our contact information is listed on the screen. And a question regarding the slides. Will we have access to the slides? I believe, yes, they can be downloaded after the presentation. And if you have any issues with that, just reach out and we'll provide them offline. Question regarding CBD. Questions are rolling in now that I'm ready to hang up. So let's answer a couple of these with my colleagues. If there is no CBD, does it need to be added to the final COA label as 0% CBD? That would be for flower that's expressed in percentages. I believe the answer is yes, but I would love to hear from some of my packaging and labeling guru colleagues. Can anyone confirm that for the question asker?
Yes, I will confirm your answer, Cassia. That is correct. Even if there's 0%, you can say less than. You can have, one of those little less than symbols and say less than 2.0 milligrams per serving or per package of CBD. But you need to note that there's no CBD or less than 2 milligrams of CBD per serving or per package.
Yeah, and I think the less than, if you're going to pre-label in particular, the less than symbol is a good way to go so that if you have your nominal deviations during testing that you're not anticipating, it doesn't require a change to the label. Other question that you may want to field, Andrea or Christina or Genevieve, where does the name of the branding need to go on a package and what size does it need to be?
Christina, you want me to take that or you want to take that?
Sure, Andrea, that's fine.
So the branding should be on the primary panel, the display panel. There's actually not a specific requirement of what panel the branding needs to be on in the regs. So my suggestion is to put it on the primary panel, not required. And then as far as size, again, there's no specific requirement for size. You just want to think about it in relationship to your product identity statement. So whatever your branding font or size looks like, just keep that in mind in relationship to your product identity.
Thanks, Andrea. Another question regarding CBD products without THC. This may be up your alley, Andrea. The question is, do CBD products without THC need any kind of CR or tamper-evident packaging? So the answer to that question depends in part on whether the products are going to be marketed as cannabis products sold through the regulated cannabis marketplace in a dispensary or through a licensed delivery operator, or if the products are going to be sold as hemp derived CBD products outside of the regulated marijuana, THC cannabis environment. If you're selling it in a dispensary and the CBD is derived from, cannabis of the marijuana variety, then it needs to meet the same requirements as any other cannabis product sold through the regulated market. If it is a derived CBD product that has a wider capacity to be sold online and via other forums, I'm not sure that there's not a universal requirement for CR packaging, but Andrea, as our sort of hemp expert, are there best practices for child-resistant packaging for certain types of CBD
outside
products?
of the cannabis regulatory environment, there's no requirements. There's no requirements
Universal.
Really in any state for CR or tamper-proof packaging. States are. California has nothing at the moment, but they're considering regulations for hemp-derived CBD products sold outside of dispensaries. There isn't anything in those proposed regs regarding CR or tamper-proof packaging, but there is requirements in there for warnings to be put on the package, like do not keep out of reach of children and, do not use if you're pregnant or breastfeeding. But no requirements on CR or tamper-evident packaging.
Thanks, Andrea, and thanks, Christina and Genevieve. With that, I think we will conclude today's panel. Thanks to everybody for some excellent questions. And again, if you do have any follow-ups or anything that comes to mind, shoot us an email. I did receive confirmation that slides and the video replay will be sent to all registrants within the next several days. I hope everybody has a good and safe week wherever you are, and we'll look forward to chatting with you again in this forum sometime very soon on another regulatory issue. Take care, all.